Welcome to week 11 of evidence. This week we continue our discussion of opinion testimony. We'll cover the cases from your casebook on pages 820 to 852. The first case is People v. Sanchez. This is a Supreme Court of California case from 2016. The defendant was tried on firearm and gang-related charges, and one of the key prosecution witnesses was David Stow, who was a detective and gang expert. At trial, Stow testified about gang culture in general and about the specific gang at issue in this trial. Stow then testified about the defendant personally, discussing defendant's statements in the Street Terrorism Enforcement and Prevention Act notice that the defendant had received, which was essentially putting him on notice that he was associating with a known gang, and it also included statements made by the defendant to the law enforcement and was also included some recordings of the interactions. Based on this notice, the witness testified that in his opinion, the defendant was a member of the Delhi gang and that his actions were intended to help the gang. The defendant was ultimately convicted at trial. At issue was, did Stow's testimony improperly violate the defendant's Confrontation Clause rights? This court held that when Stow testified to case-specific facts that were based on hearsay statements in that notice the defendant had received, which is what he based his opinion testimony on, he was reciting hearsay statements to the jury. And so if these statements were testimonial, then there would be a Confrontation Clause violation, unless the declarant is unavailable and the defendant had had a prior opportunity for cross-exam, which is the standard for the Confrontation Clause. In this case, the court held that the statements were testimonial and the defendant had not had an opportunity to cross-exam, and therefore the error was not harmless. The next case is United States v. Keys. This is a United States Court of Appeals case from the Fifth Circuit from 2018. In this case, the defendant was convicted of sex trafficking. The defendant later objected to testimony by two police officers that discussed his guilt and also his truthfulness. The officers were questioned on the elements of the crime, given specific facts from the case. One officer also testified that he believed the defendant was lying during the investigation. Ultimately, the defendant was convicted. At issue is whether the officer's testimony was improper. On appeal, the court held that the trial judge did not err in admitting the officer's testimony on guilt. The prosecutor didn't ask the officer if they believed the defendant had committed the charged crime, which would have been improper, and instead they questioned the officer on specific factual details that built up to the ultimate crime, which the court held was proper. It's a little bit of a strange ruling since the ultimate end result is the same, but the court noted that the first way of asking the officer if the defendant had just committed the crime would have been improper, but how they questioned him at trial in this case was proper. On the issue of truthfulness, the court held that the officer's opinion did not state a legal conclusion and was not based on any specialized knowledge. The court found that the testimony was based on the officer's perception or his personal knowledge and was helpful to the jury, which is our standard for a lay opinion. Our next case, United States v. Diaz. This is a United States District Court case from the Northern District of Georgia from 2013. As background, the defendant was charged with armed robberies and other offenses. At trial, the defendant claimed the defense of insanity. In a pretrial motions in limine hearing, the judge found that the defendant had not yet presented clear and convincing evidence of that insanity. The defendant presented a report from his expert witness, his doctor, asserting that the defendant was unable to appreciate the nature and quality or wrongfulness of his actions because of his mental illness. At issue was should the court have considered the defendant's expert's report as evidence of his insanity defense. Under the Federal Rule 704, this expanded expert opinion testimony to include ultimate issue testimony, which prior to the rules was excluded. However, Rule 704B has an exception to this and bars testimony in criminal cases as to the ultimate issue specifically in an insanity defense. The court held that the defendant's expert could not testify that he would be unable to appreciate the wrongfulness of his acts, but that the defendant's expert could testify to his diagnosis, the characteristics of his particular mental illness, to his mental state and motivation at the time of the crime. Our last case is Daubert v. Merrill Dow Pharmaceuticals Incorporated. This is a Supreme Court case from 1993. As background, the plaintiffs allege that the defendant's prenatal drug, Bendectin, caused serious birth defects in her children. At trial, an expert witness testified that after reviewing extensive published scientific literature on the drug, it was the expert's opinion that this drug did not show a risk of human birth defects. The plaintiff responded with their own experts that testified that the drug had caused birth defects in animals, but the court determined that the plaintiff's experts did not meet the standard of general acceptance for admission of an expert witness testifying to scientific knowledge. This test was the Frye test, which was the current case law at the time. At issue was should the plaintiff's expert witness testimony have been allowed at trial. The Supreme Court held that the FRE, not the Frye test, should have controlled when this expert testimony, scientific testimony, should have been admissible. And in this opinion, the court made a factor test for judges to consider. So first to consider was, has the theory or technique been tested, or could it be tested? Has it been subject to peer review and publication? What is its known or potential error rate? And is it widely accepted in the relevant scientific community? Ultimately, the appeals judgment was vacated and the case was remanded.